Good Okay.
Yeah.
Okay. Good evening. I'm Carl Martin. I'm a neighborhood safety officer, and we're just going to take it in the order that it's on the docket today. And we're going to start with 3155 Beechwood. And go ahead, sir. Let's talk about this particular issue at this property.
Well, I sent quite a few photos. The bottom line here is it's a rental that my mom was living in. I've been trying to clean it out and move both of us. And I just closed on a house like maybe 2 or 3 weeks ago that we're moving into. So the vast majority of what's been moving and going to the trash is trash, but also a lot of food and stuff that I've been storing up and taking out to Montrose. So like there was no like rotting food or anything like that for one thing. And I had a camper 3 months ago that I brought here and was told that as long as my vehicle was attached to it, it was all right on the street, but I still got an orange ticket on it anyway. So I moved that within like 2 days of the ticket, but I brought it here to move a bunch of my stuff.
So the vehicle, okay, so at the vehicle, that particular situation, that's not going to be germane to this proceeding. So let's just focus on the trash and debris that's at the property that the ticket was issued from, sir.
Well, that's what I'm saying. For the last 3 months, I've been cleaning this place out and getting rid of stuff. Like every week, it's a giant pile out front. My mom had all the grandkids here. There was all kinds of cardboard and boxes and
right. So
fruit.
Right. So what I have here from the officer that issued the ticket, I have in the course of her daily business on said dates that she had listed on 7/30/2021, she had gone out both then and also back on 6/30/2021 and recorded the items as we found, at the property. And I have pictures as well. I know you probably can't see the pictures, but she took pictures.
No, yeah. The first time around, that was a lot of stuff that went out that week. I was already working on that. That's my whole point is I've been working on this for 3 months. I'm almost done.
Right.
But it's messes that were left behind that I have to clean up. Nobody else that made the mess is here to do it. So I've been doing it. And, it's not like it's been sitting for weeks and weeks and weeks at a time, the same stuff.
Okay, so what happens is the officer goes out. They put a warning initially, 3-day warning, to start making progress. And it appears from the pictures that I'm looking at a picture that shows those cardboard boxes. There's food in a plastic container that I can see in the picture. There is trash cans, Home Depot bucket. I also have all these appears to be cardboard boxes, again smaller, that are laid out. And there is
the cereal boxes.
Items, cereal boxes. Okay, and there are items of questionable value that are okay.
My point in sending those is that, one, I'm trying to demonstrate the sheer volume of dry goods I have been storing up and moving, because that pile of cereal boxes is long gone in last week's trash. This is not like, there's two things happening. I'm emptying out a crappy rental, and in the meantime, I'm trying to get my stuff and myself out of this area. And I'm moving up north. So I've been buying 55-gallon drums from Kogel's for cheap, $5 a barrel. They're food grade. And I probably have, no exaggeration, about 2 or 3 dozen stored out at my buddy's property in Montrose. I fill up 5 or 6 of them. I take them out there. So what you're looking at was this week's load right at the end of my driveway, and any cardboard around it has already been out. There's a new group of things going out right now, which is what you're looking at, which is ginger snack,
right?
Ginger snack, M&Ms,
All right.
you know, the Smarties. I mean, you see the sheer volume of food that I'm stacking away. This is not
right. So that sheer volume is great and dandy, I guess, for you for future use. But the problem is the fact that it's out and it becomes an eyesore at the neighborhood, and the officer.
But that's what I'm saying. It doesn't stay out. That's what I'm saying. It doesn't stay out. I'm not going to leave these barrels out any longer than it takes to fill them, and then they go. So there's nothing just sitting around. That's my point.
But my point is this operation, if you were in a warehouse or someplace enclosed or someplace where it's not all over outside, you know, even out towards the sidewalk, the public sidewalk, it's totally visible. I mean, you know, I get the fact that, you know, that there's a lot of mess here, but your operation in terms of your storage procedure is not exactly a normal process that most people want, you know, in a neighbor doing right across from them or even next door to them.
Well, I'm the point is I'm moving.
Okay, but even though you're moving, sir, you cannot create this type of eyesore with trash and debris and items of questionable value.
So there's no questionable value here. There's hundreds of dollars of food here. Hundreds. I just paid $50 just for those Smarties and those Nerds and those Runts.
Well, what I'm trying to tell you,
there's nothing questionable about it. I have gourmet food stacked away. What I fail to understand is if someone's moving, they can't have stuff in between their house and the moving truck. I mean, I've got my truck right here with the trailer that I use, and you have pictures of the white trailer there, where those barrels are constant movement.
Well, those barrels that what I'm looking at right now is an eyesore. It's out in front of the property, just, you know, right next to the.
So me standing. Wait. So let me get this straight. Me standing here with the rag and a bunch of food, stacking them into these barrels and getting them ready to be put on. It's not an eyesore.
If you did if you did it inside, like, you know, in a garage, say, where nobody's watching.
There's no garage. There's no garage.
So there's no garage. So the bottom line is that the officer issued a warning based on the fact that this stuff was out there. It was a complaint that was received by the office. So the neighbors were complaining. You were given
not my neighbors.
To start again. I don't know who's complaining, but obviously a complaint was generated.
Well, I think it's really funny because if you walk up and down the street, there's a heck of a lot worse messes. And I might add, I have videos that you guys can't view of your officer, and you know, I really feel like not all my evidence is being able to be presented here. And I'm like,
all right. So,
sir, I don't have any representation. I mean,
let me ask.
What we're arguing about is literally apples and oranges, because these 4 barrels I just sent pictures of to you today will be gone today. In fact, if I wasn't having to do this every couple of weeks, I could have a lot more done. I spent the last 4 hours trying to send pictures and video as evidence, when I could have spent the last 3 or 4 hours finishing up this job I got going on right here.
Well, here's the bottom line. Sir.
Yeah.
Sir, we're done. We obviously are not going to come to any resolution here. And
why
that's
not?
why. Because we're not.
Why not?
Because it's clear to me, based on the evidence that's before us and the ticket. I mean, we're not arguing that the stuff is out. So in other words, we're not disputing the material issue that this stuff was out and it was seen and it was in the process of whatever you were doing with it. But the officer gave you 3 days to start cleaning it up, and it was not done. And you admitted
it was done. It was done.
That sheer volume and the fact
wait a minute.
That it's outside. It's even outside the fence on the public sidewalk. So that being said, sir, we're not going to reach resolution. So I think when the judge comes back, we're going to go ahead and we are going to set this for trial. And then we will present this evidence that we have before us.
So I get a public defender, right?
Pardon me?
So I get a public defender, right?
Sir, I am not going to advise you on your legal rights. That is up to you to, educate yourself. All I'm saying is,
if we're going to trial, then I know I'm entitled to a public defender. I'm also entitled to see the information that you have before you, because for one thing, you're just dictating. You've got pictures from her from months ago, and you cannot say with any certainty that that's the same stuff that I sent you pictures of today, which means I did in fact move the stuff and get rid of the stuff that I was cited for. Now we're talking about,
sir, when you're cited, by the time that ticket is written, those pictures are taken. So what you do after that is immaterial. It's immaterial. I mean, that's a point in time.
You just said she gave me a 3-day warning to clean it up, and I did. So it is material. It is material.
Sir, because
it's not the same stuff.
She took pictures of when she issued the ticket. She took pictures when she went out there. And those are the pictures that we have. So you'll get to see them when we have.
But it's not the same stuff. That's the point.
Okay, so I think we've reached our limit here, sir. When the judge comes back, we're going to advocate that we go ahead and go to trial on this matter, right? And you are not the landlord; you're the tenant that created the mess. Is that correct? I want to make sure I'm clear.
I have nothing more to say because you might use it against me. So that's it.
Okay.
We can go ahead and judge in here and get a trial going.
Okay, that's fine. All right. Thank you, sir. All right. Okay, and the next address we're looking at, I believe, 3237 Montana.
Yeah, that's the address.
All righty. So what we have here is, again, it's trash and debris at the property.
Yeah.
Okay. Are you disputing that there was any trash and debris at the property?
Oh no, I know it's there. It's not me that lives there. It's just the property's in my name. There's a tenant. He didn't inform me when he had gotten the citation, and he's apparently got a bill also for like $50 or something.
Okay, that's the price of the ticket. Yeah, that's the price of the ticket. Okay.
When I got this paperwork, I contacted him, and he told me about it and all that stuff. But yeah, I'm aware what's the property looks like. It looks like shit. There's a bunch of stuff out there.
Right. Right. That's correct.
Yeah. I know that it's a loose family member. My aunt. The house was bought by my grandparents for my aunt who passed earlier this year, and his husband or her husband is the one that's at the property there. He's a scrapper, you can tell from the pictures. Obviously, he's got tons of metal and shit there. Is he allowed to do that out of his backyard and just not in the front yard? Is that what you guys are saying? I just want to understand what the.
No, it's not allowed. Scrapping is not allowed in the residential area for obvious reasons.
Okay.
It lowers the property value.
Mm-hmm.
I've been to that property myself on other occasions.
Yeah,
it's been an ongoing issue for a long time, and there's just no other way of saying it. But you cannot have any type of agreement with somebody that's going to continue to do what he's doing, and unfortunately, it's become a very how should I say it? It's become a very despicable sight for the other neighbors that are in the area. So I'm glad and I appreciate your honesty in admitting that, yeah, it looks really bad. It does. Yeah. And it's not getting any better. And, that, like I said, we don't have an argument there.
No, we don't.
Here is the fact that, yeah, it's the ticket was issued and it goes to whoever owns it, which is you as the owner.
Yep. The ticket wasn't sent to me though. It was placed in the tenant's mailbox at the property.
It was placed in the tenant's mailbox. Okay, so even though it was placed in the tenant's mailbox and stuff, you're saying, how did you become aware of it?
When I got this paperwork for this hearing in my mailbox.
All righty. Okay, so you got that. Okay, so what I'm looking at here is I'm looking, and your name is Zachary?
Yes, correct.
Yep, and Zachary, you at 4393.
No, that's incorrect. That's my old address. I'm at a new address now.
Okay, so you're at a new address. At the time,
Yes, I was.
when this property was listed, you were at this old address. Okay.
Yep.
So what happened is that this got mailed out to that old address. Now I don't know if it wasn't forwarded, which is possible, depending on when you moved. But that being said, a notice is placed on the property, and another notice is sent via U.S. mail to the last known address of the property owner.
Okay.
So there's a two-system notification. One is at the property itself, and the other is at the last known address. So if you didn't get that originally because you moved, then you got to go and update that information as part of your agreement as being a landlord or renting it out. I mean, that's in the
But
paperwork.
I mean, I'm not renting it to him. He's just living at the property. I'm not gonna lie.
Okay, so
I'm
he's
aware.
not a renter? He's just squatting there. Is that what you're telling me?
No, he's not squatting. We're allowing him to live there.
Okay, all righty, okay. So I guess where we're at with this particular case is that we're just, like I said, he's scrapping, he's been doing it, he's continuing to do it, he continues to violate. He's got that going on, he's got vehicles. I mean, I can go on and on. Bottom line is,
It's gotta go, basically.
Yeah, basically, yeah. I mean, it's got to be cleaned up, but bottom line, I don't see anything here that counters what I've just said. And based on that, this ticket is valid. Service was done in the regular course of business. And I think if you're in agreement, when we bring the judge back, if we come to that agreement, I'm just going to advocate that we enforce the ticket. It's $50. Yep. I suggest that you might want to, maybe he'll listen to you more than he will any of us. And you might want to start encouraging him to get rid of all of that. As long as you start making some progress.
Yeah.
Because it's going to take a long time, because he is really, I'm talking at least months.
I just drove by this afternoon to make sure, because we told him to start cleaning it up. And
it's going to take months.
He said that he was, but he's not.
He's not. Right. Right.
So at this point,
I can tell you, the best thing
I'm going to go ahead and tell him he's got to get out if he's not going to clean it up at this point.
Right. Or you can say, hey, you can stay, but you got to start making progress. As long as you start making some progress, we're going to work with you. Okay. But it's got to be real, tangible progress. If we go by there and it's in worse condition, or he hasn't done anything, then then we're back to square one, and more tickets are going to be coming down. From here on out, they keep going up. Okay.
Yep.
100, 200. Once it hits 200 level, every time we go out there, it's just 200 automatically. We don't go back. Okay. So just so you know, I think if you're in agreement, I would like to advocate with the judge. Let's go ahead and enforce this ticket.
That works.
And the stipulation that you will be talking to him, and when you speak to him, it will actually start making some progress.
Yeah, I'm gonna give him 30 days to get some progress done on it. If he doesn't get something done in 30 days, then I'm gonna tell him he's got to go, and I'll clean it up myself.
Okay, very good. Alrighty, I think that's the fairest thing we can do. Thank you, sir.
Yep.
Okay. All right.
All right. Are we ready for attorney Feaster?
Yes, yes. Absolutely.
Okay. Hang on just a minute.
All right. Alyssa, are we recording?
Yes, we are recording.
All Okay, we are back on the record. This is the City of Flint's Administrative Hearings Bureau or Blight Court. My name again is Attorney Feaster. I am the Administrative Hearings Officer or Blight Court Judge. Present via Zoom, we have our Administrative Hearings Office Clerk or Blight Court Clerk, Ms. Alyssa Oliveris. And present, we have our Neighborhood Safety Officer, Mr. Carl Martin. We do have 2 residents present. I did step out of the room and give them a chance to discuss their matters. Let's start with the first one on the top of the docket. Let's start with the address at 3155 Beechwood, file number EN 2107226. Alleged code violation of 39-7, which is the duty of the property owner to keep the premises free from litter. The owner operator there is a Ronald Birchmeyer LLC. And if I recall correctly, we have the tenant here present on the phone. What is your name, sir?
Adam Garrix.
Adam Garretts.
Yes, sir.
All right, Mr. Garretts, my understanding is that you and Mr. Martin spoke. I'm going to swear you both in and ask you guys where we stand at this time. Mr. Martin, you swear to tell the truth, the whole truth, nothing but the truth?
Yes, sir.
Mr. Garretts, you swear to tell the truth, the whole truth, nothing but the truth?
Yes.
Okay, where do we stand on this matter, gentlemen?
Well, Your Honor, I did have an opportunity to talk to Mr. Garrett. We discussed the evidence before us, and we were unable to come to a resolution. And I'm recommending that we set this case for trial based on the evidence that are contained therein concerning this property. We do not dispute that the property did have litter added at the time that the officer issued the ticket. And we have photographs that document that fact.
Well, help me understand that. What are we disputing?
We're in dispute. Mr. Garrett is of the opinion that because he was moving things out and he had a large volume, that items were being moved out, and therefore a ticket should not have been issued.
Okay.
Based on the fact that he was moving items out.
Okay, fair enough. Mr. Garrett, does that sound about accurate?
Not exactly. No resolution was offered. He just wanted to disagree with me and didn't. He said couldn't have a resolution. I would offer to just pay the fine and be done with it because the trash has been removed.
Okay.
Or he told me the other option was to take it to trial. And if that's the case, then I don't want to. But what I need to know is, am I afforded a public defender?
So a couple things. One, you do have the right or ability to pay the fine or ask for a reduction in the fine and pay the fine that I assess and be done with this matter. You also have the right to have a formal hearing or a trial where the city has to prove you are in violation of the ordinance 39-7. If you do elect to have a formal hearing or a trial, since this is not a criminal matter, you are not given a public defender because you're not looking at jail time. You would only be looking at a monetary sanction. So you do not receive a public defender in this kind of case. But like I said, you can hire a lawyer, or you can appear on your own and present any evidence you want to refute the city's case. But I thought I might have heard you say that you would be okay paying a fine and wrapping this matter up. Did I hear that correctly or incorrectly?
Indeed, Your Honor. If a reduced fine would be very, very welcome, because I don't have a lot of money.
Okay.
And in part, I am moving. I just bought a new house. I just closed 2 weeks ago.
Okay.
And as I tried to explain to the gentleman there, I'm doing 2 things. I'm moving my mother's things and all of this garbage out to the road. Every week, it's the same size pile until it's done. In the meantime, I'm trying to move as well. So I don't need, he tried to tell me that packing things on the side of the road and putting them in a truck is a blight issue. I don't understand how that could be, because these barrels that he has pictures of today are leaving tonight once they're full.
I understand.
So
And I'm willing to do that for you. I'm willing to offer you I don't think I've had you in this court before. So I'm willing to offer you a reduction of the fine and have you pay that and resolve this matter. But I'm also willing to make the city prove that you did violate the ordinance. And if they can't prove it, then this matter would be over. But I am willing to offer you a reduction. Alyssa, what is the total amount that appears to be owed?
There's a total of 150 resulting from 2 tickets.
Okay. And he's never been here before. So Mr. Garrett, I would be comfortable dismissing the second ticket and having you pay the first ticket as a compromise, if that is something you would want to do to resolve this matter.
That's fine. Is that also an admission of guilt?
I wouldn't call it an admission of guilt. It's not something that goes on your record. This is just a city ordinance violation, and you could accept responsibility and resolve it.
The other thing is it would be what, $75?
I think the first ticket is $50, and there's a state cost of $10 for a grand total of $60.
I can probably pay that in about a week or so.
Okay, is that how you would like to resolve this?
If that's all right.
Okay, I don't have a problem with that. I don't know, it's my decision, but I will ask NSO Martin if he has a strong objection to that resolution.
You know, Your Honor, I don't have a strong objection. We never did get to the point of trying to resolve the issue of these tickets. So I feel comfortable with that. That sounds fine.
Okay.
If we can resolve that matter, I don't have a problem with it.
Okay, so Mr. Garrett, let's do that then. By the agreement of the parties, I will enter a stipulated judgment where we throw out the second ticket. You are responsible for the first ticket, which is the $50, and the state mandatory cost of $10 for a total of $60. We'll send a notice to you at the 3155 Beechwood address. If you can get that paid in the next 2 weeks, is that enough time?
It should be, yeah.
I can give you a little more if you need a little more.
Well, I mean, right now I'm waiting for like 700,000 other people. I'm waiting for my pandemic unemployment to be released. So
Okay.
I really don't have much of anything but donating blood twice a week.
How about, look, let's give you a month, okay? Let's give you 30 days and see if you can get it paid in the next 30 days. And if you do, then we'll dismiss this ticket, and you won't have to deal with us anymore.
Okay.
Sound fair?
No, but I agree.
You're willing to accept that?
Yes.
Okay, all right, well, that is what we'll do. Ms. Oliveris will prepare the paperwork, and that's all we have for you today.
Thank you, sir.
Okay, have a good day.
I can go now?
Yep, you're all set.
Okay, thank you.
All right. We'll move down the docket. Let me first call this case that's dismissed. We'll call the address at 2301 Pennsylvania, file number EN 2107218, alleged code violation of 39-7, which is the duty of the property owner to keep the premises free from litter. The owner operator is Daniel Perkins. That file is paid in full. It will be dismissed and closed. Okay, moving down to the next matter on the docket. That's the address at 3237 Montana, file number EN 2107224, alleged code violation of 39-7, which is the duty of the property owner to keep the premises free from litter. The owner operator there will be a Zachary Bergenhart. Am I saying that right, sir?
Berghart.
Berghart, I'm sorry. There's no again. I'm sorry, Berghart. Mr. Berghart, I'm going to swear you in, and we'll see if we can get this matter resolved today, okay?
Yep.
You swear to the truth, the whole truth, nothing but the truth?
Yes, sir.
Okay. Mr. Berghart, my understanding is you had a chance to meet with NSO Martin here. You all discussed this matter. Where do we stand at this point, gentlemen?
Your Honor, yes, if it so pleases the court, we have come to the understanding and agreement that the material issue of the fine that was issued was sustained by the property being blighted by trash and debris and items of questionable value, since the individual that's living there is scrapping all over the property, not just in the backyard, but all over. It's been an ongoing issue. And Mr. Burkhart agreed with me that, it is in that condition. He just saw it, I guess, this afternoon. And I've been there myself personally on several occasions, spoken to the tenant, the individual that's there, and he continues to do what he's doing. I have given him the opportunity, given what we've seen, that's not in dispute, to go ahead and to support this ticket as it's written, but also give him the opportunity to make some substantial progress in cleaning up the property within a reasonable time frame to start making progress in order to get rid of this eyesore in the neighborhood. And he's agreed to do that. He's going to again talk to the individual that's living there and give him a month to either clean it up or he will clean it up himself. And I think that's probably the best scenario for both himself and the neighbor and the city.
All right, so let me summarize. Mr. Burkhart owns a property. He has a tenant in that property. That tenant does scrapping. That tenant is not keeping that property clean. Mr. Burkhart is gonna take 30 days, try to see if he can get the tenant to clean that property or possibly clean it himself. And if that works out, then we'll dismiss this ticket. That's what I'm hearing.
Well, we were going to go ahead and we were going to, he agreed to pay the ticket. What the caveat is that we're not going to, give him that month and not go back there and issue more tickets, because it is in a really bad shape, and it's going to take at least a couple of months to actually clean up that property realistically.
Oh, it's that bad?
It's that bad. Yeah,
It's pretty bad.
it is bad. So,
Okay.
so what I was thinking is, I think that's the fairest thing that we can do, because the ticket should have been written, and it is in that condition. I think if we can do that, and like I said, we're hold to this agreement that we have, that within a month, if we don't start seeing progress, because we've never seen progress there.
Okay, yeah, well, that's the main goal, is
Right.
to try to get the community clean. And so, Mr. Burkhart, is that a resolution you're willing to accept?
Yeah, that's fine. I'm just gonna make him pay the ticket. He's the one doing it.
Yeah, I've been encouraging landlords to put something like that in their leases. 'Cause I think that makes it easier to enforce. So, but yeah, if you make him pay it, that's probably the best thing you can do. I'm sorry you're in this kind of situation, but with tenants.
Hey, it is what it is. He's making a hell of a mess over there. And I told him already once he needs to stop, and he didn't want to listen to me either.
Okay, fair enough. Well, based on the agreement of the parties, the stipulation, we will proceed as you both have requested. The total amount due at that property, Alyssa, is
$50.
$50. So there's a $50 city of Flint cost. There's a state mandatory cost of $10 for a grand total of $60. I don't know how long you need to pay that, Mr. Burkhart, but you go ahead and handle that, and we'll review your file in 30 days or 60 days and see where we are.
Could I get the bill sent to my current address by any chance?
Yes, what is your address, sir?
3005 Alcott Avenue, ALCOTT, AVE.
Okay.
Okay, all right. So thank you for being here today. Sorry about the situation. We'll send you that bill. Mr. NSO Martin and the rest of the NSOs will not issue any additional tickets for the next 30 days, and they will hope to see some progress. All right, good to meet you. Take care.
Yeah, nice to meet you, dude. Have a good day.
Bye.
Thank you.
All right, we'll move down to the next property, which is the address at 2312 Pennsylvania, file number EN 2107217, alleged code violation of 39-7, which is the duty of the property owner to keep the premises free from litter And 39-43 is the accumulation of growth of weeds, grass, harmful vegetation, deemed a nuisance. The owner operator is a Jeremy Mobley. It appears that I did sign a notice of hearing for today's date. No one is present on the call, no one has contacted our offices. As a consequence of their non-appearance, I am prepared to enter a default judgment in this file, should the facts support such a finding. To that end, we do have NSO Martin, who is still present and still under oath. I'll ask him what evidence he has, if any, that might support a default judgment in this file.
Thank you, Your Honor. The evidence that I have to support the evidence in this file concerning this ticket that was issued on 6/28/2021 by NSO Wilson is the ticket that was written, and on that ticket that was written on that date, she had documented finding both tall grass over 8 inches and trash at the property. Based on the information that she documented on this ticket, I recommend that we support the issuance of this ticket for the trash and debris and the tall grass over 8 inches that was at the property at that date and time.
Thank you, NSO Martin. Based on the fact this is all that I have today, there's no one here to contest this ticket. There's no one here to say that the property was not in the condition that this ticket indicates it was in. Based on their non-appearance, I will accept this as the sufficient evidence to find that there was a violation of 39-7 and 39-43, and that a default judgment is appropriate. The total amount that I see due, Alyssa, what is that?
$50.
$50 to the city of Flint. There's a state cost of $10 for a grand total of $60. We will enter a default judgment in that amount and send notice to the appropriate parties. NSO Martin, just for the record, looks like there's only one ticket with both ordinance violations on this ticket. I believe this could have probably been written as 2 separate tickets.
Yes, that is correct, Your Honor. That's correct.
And so if NSO Wilson in the future would want to do that, I think the law would allow her to do that. And we can let her know that, please.
Yes, sure.
All right, we'll move down the docket to the next address, which would be at 2314 Pennsylvania, file number EN 2107216, alleged code violation of 45-1 and 45-2. Ms. Oliveris, can you help me out with those? Hold on, I might have that here.
I believe it has something to do with the shrubbery.
Right, I think it is.
Let me just pull up the ordinance here.
The ticket says 45-1, 45-2 tall grass weeds. I don't have the ordinance right in front of me at this time.
Hang on just a minute.
Okay.
All right. Would you like me to read both of those ordinances for the record?
Yes, please.
All right. Ordinance 45-1, limitation on height. In any residence district on a corner lot, there shall be no fence, wall, or hedge more than 3 feet in height, nor any obstruction division other than a post or a column or tree not extending 1 foot in greater cross-sectional dimension between a height of 3 feet and a height of 10 feet above the established grade of either street within an area formed by the lot lines on the street sides of the lot and a line joining points on the lot lines located at a distance of 33 feet from the point on their intersection, provided that any open construction 4-foot fence lawfully existing as of the effective date of this section shall be permitted to remain.
Thank you very much.
Would you like me to read 45-2 as well?
Sure.
Okay. 45-2, obstructions to view to be removed by owner. Notice to remove. Any obstruction to the view as mentioned in this article shall be removed by the owner or agent within 10 days after service of written notice to do so by the Director of Public Works and Utilities or his or her designee. The notice may be served on the owner if he or she can be located in the city, and if not, on the occupant of the premises and on the owner by registered mail.
Thank you very much. No one has contacted our office on the file, no one is present on this file. I did sign a notice of hearing on this matter for today's date at 5 p.m. As a result of their non-appearance, I am prepared to enter a default judgment in this file, should the fact support such a finding. To that end, we have NSO Martin, who is still present and still under oath. I'll ask him what evidence he has, if any, that will support a default judgment in this file.
Yes, Your Honor, the only evidence that I have no logs, I have no pictures, I have a ticket that was written on 6/28/2021.
Okay,
Based on the information that is scarce on this particular ticket, I note that NSO Wilson cited tall grass, weeds. That ordinance would have been not the ordinance cited here as we look.
yeah.
I would recommend strongly that based on the way this ticket was written, and I note some other errors on this ticket, I would recommend that this ticket be thrown out. And
I agree with you.
I agree.
Yeah, because I was finding it a leap to get from the information on the ticket,
Correct.
the ordinances that Alyssa wrote. And even though the resident or property owner did not show up, I just don't think the face of this ticket is sufficient to satisfy the ordinance of 45-1 or 45-2.
I'm in full agreement.
Based on the request of the NSO Martin and my agreement, we will dismiss this ticket. We'll have no further action on this ticket at this time. Thank you, NSO Martin.
Thank you, Your Honor.
All right, we will move down the docket to the address of 2313 Pennsylvania, file number EN 2107215. Alleged code by, I'm sorry.
Can we pause the recording for a moment?
Yes, ma'am. We'll go off the record. Okay, this is the City of Flint's Administrative Hearing Bureau or Blight Court. Today is Tuesday, August 24th, 2021. We were discussing about to call a new property. We will go back on the record. We will call the property at 2313 Pennsylvania, file number EN 2107215. Alleged code violation of 39-7, which is the duty of the property owner to keep the premises free from litter, and 45-1 and 45-2. The owner operator there is a Christopher McMahon. I do not see anyone present on the call. No one has contacted our offices. I did sign a notice of hearing with today's date and time on it. It was set for 5 p.m. It is now 6 p.m. As a consequence of their non-appearance, I am prepared to enter a default judgment in this file should the fact support such a finding. To that end, we have NSO Martin, who is present and still under oath. I'll ask him what evidence he has, if any, that will support a default judgment in this file.
Your Honor, the evidence that I have is I have a ticket written by NSO Wilson on 6/28/2021 at this property in question, the 2313 Pennsylvania property. In it, NSO Wilson documented the fact that she was looking at trash and debris, which is the ordinance 39-7. But she also cited tall grass on the yard as well. That ordinance is 39-43, and I note that is not on this particular ticket. In reviewing this ticket as well, I note that we have these other two ordinances, 45-1, 45-2. Those are outside the purview of the neighborhood safety officers. Those are actually ordinances enforced by our building and code inspectors.
Okay. All right, thank you, NSO Martin. Per your statements there that the 45-1 and they are not able to write tickets on those issues, and the fact that this property does have those two violations included in it, at this time, I am comfortable dismissing this ticket and closing this out at this time. Obviously, if there is a ticket wrote under 39-7 and 39-43, something that the neighborhood safety officers and I can control, then I will entertain that. but at this time, I will dismiss this matter without prejudice. We'll move down the docket to the next address at 3010 Colorado, file number EN 2107219, alleged code violation of 39-7, which is the duty of the property owner to keep the premises free from litter. And again, 45-1 and 45-2, the owner operator there is a Susan Weller. This matter again was set for 5 p.m. I did send out a notice of hearing, or our clerk did send out a notice of hearing for this day and time. No one is present on the call. No one has contacted our offices. As a consequence of their non-appearance, I am prepared to enter a default judgment should the facts support such a finding. To that end, we do have NSO Martin, who is still present and still under oath. Now asking what evidence he has, if any, that might support a default judgment in this file.
Thank you, Your Honor. I do have in this particular file, I do have a log that was recorded on 6/20/2021 by NSO Wilson.
Okay.
He decided a visit to the property in question here at 3010 Colorado. However, at looking at the citation that was issued at that time, I note that, again, we have code violations that is outside the scope of the neighborhood safety officers. And based on that fact and the fact that we don't have that ability to be able to enforce those particular ordinances, I would be recommending that we dismiss this ticket, given that it's part of this documentation and it's written in this form.
Thank you, NSO Martin. Obviously, I am looking at the ticket. It does suggest that there is another ticket written under 45-1 and 45-2. It does have 39-7 included on that ticket, but I just find that having those two ordinances that are outside of the control of the NSOs and the Blight Court makes it inappropriate for me to move forward with enforcing that. As a result, I do agree with you, NSO Martin, that dismissal is the best way to proceed. So at this time, we will dismiss that ticket without prejudice. If someone wants to issue a ticket under 39-7 or 39-43 or another ordinance that is within our scope, I will entertain that. But at this time, this ticket will be dismissed.
Thank you, Your Honor.
I think that's all we have for you, NSO Martin, for today.
All righty. Thank you.
Thank you for your time. It's good to see you.
Good to see you as well. And are we still recording?
Yes.
Yes, we can go off the record.
Listen. We are back on the record in the City of Flint's Administrative Hearings Bureau, or Blight Court, for the Tuesday, August 24th, 2021 docket. Again, I am Attorney Torshell Feaster, the Administrative Hearings Officer or Blight Court Judge. Present, we have Alyssa Oliveris, the Administrative Hearings Clerk or Blight Court Clerk. We're going to move down the docket to the next section on late fees. We're going to call the address of 2933 Wyoming, file number EN 2107605, alleged code violation of 39-7, which is the duty of the property owner to keep the premises free from litter. The owner operator will be a Tina Frost. It does appear from the file that I signed a judgment in this matter on or about early August for $60. It was due to be paid by yesterday's date, or they were to have appeared here tonight at 5 p.m. No one is present on the call. No one has contacted our offices. It is now after 6:09. This matter was set for 5 p.m. Service appears to be completely correct. As a consequence of their non-appearance and non-payment, I do believe that a late fee is appropriate. The previous total was $60. We'll add a late fee of $25 for a new grand total of $85. We will send notice to the appropriate parties, and that will resolve this file for this evening. We'll move down the docket to the next property, which is the property at 1002 Persian, file number EN 2107095, alleged code violation of 39-7, which is the duty of the property owner to keep the premises free from litter. The owner operator will be a Christopher Kaiser and Barbara Farrell. Yes, Farrell. Um, It does appear that I signed a judgment in this matter for $110 that was to be paid by yesterday's date, or that which have appeared here today at 5 p.m. to explain why it has not been paid. No one is present on the call. No one's contacted our offices. It is now after 6:10 p.m. The matter was set for 5 p.m. Service appears to be completely correct. Payment does not appear to have been made. As a consequence of those factors, I do believe that a late fee is appropriate. We'll add $25 to the previous total of $110 for a new grand total of $135. Ms. Oliveris will send the notice to the appropriate parties, and that will resolve this file for this evening. We'll move down the docket to the address at 1202 Clancy, file number EN 2107091, alleged code violation of 39-7, which is the duty of the property owner to keep the premises free from litter. The owner operator there will be a MMJF Properties LLC. It does appear from the file that I signed a judgment in this matter for $210 that was to be paid by yesterday's date, or which will appear here today at 5 p.m. to explain why it has not been paid. There is no one present on the call. No one's contacted our offices. Service appears to be completely correct. It is now after 6:11 p.m. The matter was set for 5 p.m. As a consequence of their non-presence and their non-payment, I do believe that the late fee is appropriate. We'll add $25 to the previous total of $210 for a new grand total of $235. We will send those to the appropriate parties, and that will resolve that file for this afternoon. The next matter on the docket is the address of 2460 Zimmerman Street, file number EN 2107098, alleged code violation of 39-7, which is the duty of the property owners to keep the premises free from litter. The owner operator there is a Miranda Eastep. It does appear that I signed a judgment in this matter for $60 that was to be paid by yesterday's date, or the which will have appeared here at 5 p.m. to explain why it has not been paid. It is now 6:12 p.m. No one is present. No one has contacted our offices. Service appears to be completely correct. Payment does not appear to have been made. As a consequence of their non-appearance and non-payment, I do believe the late fee is appropriate. We'll add $25 to the previous total of $60 for a new grand total of $85. We will send notes to the appropriate parties, and that will resolve this file for this afternoon. The next matter on the docket will be the address at 6907 Parkbelt Drive, which is file number EN 2107100, alleged code violation of 39-43, which is the accumulation of growth of weeds, grass, harmful vegetation during the nuisance. The owner operator there is a Charles and Benita Hunt. It does appear from the file that I signed a judgment in this matter on the 23rd. Excuse me, I signed a judgment in this matter for $210 that was due yesterday on the 23rd, or they would have appeared here today at 5 p.m. to explain why it has not been paid. There is no one present on the call. No one's contacted our offices. Payment has not been made. Service appears to be completely correct. And it is now after 6:13 p.m. This matter was set for 5 p.m. As a consequence of those factors, I do believe that the late fee is appropriate. We will add $25 to the previous total of $210 for a new grand total of $235. We will send notice to the appropriate parties, and that will resolve that file for this evening. The next matter on the docket is the address at 741 East Alma, file number EN 2107150, alleged code violation of 39-7, which is the duty of the property owners to keep the premises free from litter. The owner operator is a Timothy Moreland. It does appear from the file that I signed a judgment in this matter for $60 that was to be paid by yesterday's date, or which will appear here today at 5 p.m. to explain why it has not been paid. No one is contacted our offices. No one is present on the call. It is now after 6:14 p.m. The matter was set for 5 p.m. Service appears to be completely correct. As a consequence of those factors, I do find that a late fee is appropriate. We'll add $25 to the previous total of $60 for a new grand total of $85. We'll send notice to the appropriate parties, and that will resolve that file for this evening. The next matter on the docket is the address of 2117 Arlington Avenue, file EN 2107212, alleged code violation of 39-7, which is the duty of the property owners to keep the premises free from litter. The owner operator there will be a Michael P. Sennett. It does appear from the file that I signed a judgment in this matter for $360 to be paid by yesterday's date, or the word to have appeared here today at 5 p.m. to explain why it's not been paid. There is no one present on the call. No one has contacted our offices. Payment has not been made. As a consequence of these factors, excuse me. I lost track of my document. There we go. As a consequence of those factors, I do believe that a late fee is appropriate. We will add $60 to the previous total of $360 for a new grand total of $385. We'll enter a judgment in that amount and send notice to the appropriate parties. That will resolve that file for this evening. The next matter on the docket will be the address at, sorry,
Oh, you're good.
at 2613 Vernon, file number EN 2107205, alleged code violation of 39-7, which is the duty of the property owner to keep the premises free from litter. The owner operator there would be I believe that one is going to be a Deborah Brown.
Yep.
I'm sorry, let's go back. I skipped the one car. We're going to call the one at 3014 car, file number EN 2107207, alleged code violation of 39-7, which is the duty of the property owner to keep the premises free from litter. The owner operator there is a Merle Scott. It does appear from the file that I signed a judgment in this matter for $60 to be paid by 8/23, or they were to have appeared here today at 5 p.m. to explain why it's not been paid. There is no one present on the call. No one has contacted our offices. Service appears to be completely correct. It is now after 6:17 p.m. The matter was set for 5 p.m. As a consequence of those factors, I do find that a late fee is appropriate. We'll add $25 to the previous total of $60 for a grand total of $85. We'll send notice to the appropriate parties, and that will resolve that file for this evening. Now, the next matter on the docket is the address of 2613 Vernon, file number EN 2107205, alleged code violation of 39-7, which is the duty of the property owner to keep the premises free from litter. The owner operator there is a Deborah Brown. It does appear from this file that I signed a judgment for $160 to be paid by yesterday's date, or they were to have appeared here today at 5 p.m. to explain why it's not been paid. No one is present on the call. No one has contacted our offices. It is now after 6:17 p.m. The matter was set for 5 p.m. Service appears to be completely correct and payment does not appear to have been made. Based on those factors, I do find that a late fee is appropriate. We'll add $25 to the previous total of $160 for a new grand total of $185. We will send notice to the appropriate parties, and that will resolve that file for this evening. The next matter on the docket is the address of 2513 Maryland, file number EN 2107213, alleged code violation of 39-43, which is the accumulation of growth of weeds, grass, harmful vegetation deemed a nuisance, and 39-7, which is the duty of the property owner to keep the premises free from litter. The owner operator there would be an Arnold Randall. It does appear from the file that I signed a judgment in this matter for $160 that was to be paid by yesterday's date, or they were to have appeared here today at 5 p.m. to explain why it's not been paid. It is now after 6:18 p.m. Service appears to be completely correct. No one is present on the call. No one has contacted our offices. Payment does not appear to have been made. Based on those factors, I do believe that a late fee is appropriate. We will add $25 to the previous total of $160 for a new grand total of $185. We will send notice to the appropriate parties, and that will resolve that file for this evening. The next matter on the docket is the address at 2517 Maryland, file number EN 2107214, alleged code violation of 39-7, 39-43, which is the accumulation of growth of weeds, grass, harmful vegetation deemed a nuisance, and 39-7, which is the duty of the property owners to keep the premises free from litter. The owner operator there is a Timothy Randall. It does appear from the file that I signed a judgment on this matter for $160 that was to be paid by yesterday's date, or they were to have appeared here today at 5 p.m. to explain why it's not been paid. It is now after 6:19 p.m. No one is present on the call. No one has contacted our offices. A payment has not been made, and service appears to be completely incorrect. Based on no factors, I do believe that a late fee is appropriate. We'll add $25 to the previous total of $160 for a new grand total of $185. We will send notice to the appropriate parties, and that will resolve that file for this evening. The next matter on the docket is the address at,
Let's see, 3701 Whittier.
yes, 3701 Whittier, file number EN 2107208, alleged code violation of 45-1 and 45-2. The owner operator LBA Stephen and Lori Gale. Obviously, this is one of the ones that we were just talking about with NSO Martin. I did sign a judgment in this matter. However, if we sign that judgment based on the ordinance violations of 35-1 and 35-2, which it does appear that we did, then I think this matter would need to be dismissed rather than having a late fee added, because those ordinances will be outside of the blight court's control. Based on those facts, I'll have Ms. Oliveris confirm that the ticket is issued on those ordinances. And if it is, we will dismiss that matter without prejudice.
Okay, let me get to these tickets. So I will note that these tickets were entered into evidence at the 7/27/21 hearing, so July 27th, 21. And the tickets that I'm looking at, were total for 150. We issued a judgment for 160, and they were written for ordinances 45-1 and 45-2.
Okay. Based on the new information that we learned this evening and figured out that that is not within our purview, I don't think we're able to collect those tickets. So we will dismiss those matters without prejudice and allow the buildings office to charge those tickets if they feel that is necessary. That is the last matter we have on the docket for this evening. Based on that, we will go off the record. And well, I should say, before we get off the record, so thank you, Ms. Oliveris, for your service. Thank you for your time. Thank you for your work here in the city of Flint. We know you're going to be moving on, and we wish you the very best in your next endeavor. Good luck to you, and thank you again for all you've done for the city of Flint.
Oh, my pleasure. Sorry, my camera is broken and I can't show my face and say thank you.
No problem. No problem. We just appreciate you. So good luck, and look forward to hearing from you as you grow into your next positions.
Thank you.
All right, we go off the record.